Hello friends, welcome to the point. In today's session we'll be discussing about the corporate affairs. So this is a topic from India Yearbook. So the Ministry of Corporate Affairs is primarily concerned with administration of the Companies Act 2013. The Companies Act, it is also concerned with the Companies Act 1956, the Limited Liability Partnership Act 2008 and other allied acts and rules and regulations that are framed thereunder mainly for regulating the functions of the corporate sector. So this ministry is also responsible for administering the Competition Act 2002 just to prevent the practices having adverse effect on competition. So to promote and sustain competition in markets, to protect the interest of consumers through the commission set up under the act. Along with this, it also exercises and the supervision over the three professional bodies. So the three professional bodies are Institute of Chartered Accountant of India, Institute of Company Secretaries of India, and third one is the Institute of Cost Accountants of India. So these three, they are constituted under three separate acts of the Parliament for proper and orderly growth of the professions concerned. Ease of doing business. So the ministry, it has prescribed a simplified proforma or a simplified formula we can say for incorporating companies. So that it is called, in short it is called as SPICE. S-P-I-C-E. That means simplified proforma for incorporating companies along with EMOA. That means Electronic Memorandum of Association and Electronic Articles of Association. This too, it eliminates the requirement of physically signing the Memorandum of Association and the Articles of Association by the applicant, and it helps the entrepreneurs to start business in India without much hassles. So that is called ease of doing business. Companies Act 2013. So this Companies Act 2013, it seeks to bring corporate governance and regulatory practices in India at par with global best practices. The corporate sector, it has been given more flexibility in regulating its own affairs, which is subject to full disclosure and accountability of its actions while minimizing government interference. So this act, the Companies Act, it provides more opportunities for new entrepreneurs and it enables wide application of information technology in the conduct of affairs by corporates. So the key features of this Companies Act 2013 is, it is business friendly, corporate regulations, or we can say as pro-business initiatives. So this is a provision of self-regulation with disclosure or with transparency instead of government approval based regime. So next is, it has a good CSR, that means corporate governance and corporate social responsibility. So this concept of independent directors, it is included as a statutory requirement here. So women director for prescribed class of companies, mandatory provision for constitution of CSR committees and formulation of CSR policy with a mandatory disclosure for prescribed class of companies. It enhances accountability of management. It has a strengthened enforcement. That means the central government has to have powers to order investigation suo motu in public interest. Next is to audit accountability. So recognition of accounting and auditing standards, stricter disqualification norms for auditors and all those things. Next is investors protection. So stringent norms for acceptance of deposits from the public, strengthened role of investor education and protection fund, which is called as IEPF, Investor Education and Protection Fund. For this, no time bar on claims of dividends from IEPF. So class action suits are recognized, and it enhanced powers to tribunal for protection of minority rights also. So this is all about Companies Act 2013. So in the Companies Act 2013, some amendments were made in the year 2015. So that is called as Companies Amendment Act 2015. As I said, the Companies Act 2013, it was amended through Companies Amendment Act 2015 to facilitate business and address certain immediate concern that is raised by the stakeholders. So these amendments, along with the relevant rules, it have been notified, and they provide exemptions under various provisions of the Act. Under various provisions of the Act to private companies. So those exemptions are for private companies, government companies, and the section 8 companies and nidhis. For all these 4 categories, there are certain exemptions. Insolvency and Bankruptcy Code. In short, it is called as IBC. Insolvency and Bankruptcy Code 2016. So this IBC code, it became functional from May 2016. So then the Government of India, that is Allocation of Business Rules 1961, it were amended wherein the Ministry of Corporate Affairs, it was entrusted with the responsibility to administer that code, that is the IBC code. This code, it has been framed with objective to consolidate and amend the laws that relates to reorganization and insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner. And there is a board called IBC board, that is Insolvency and Bankruptcy Board. So this board of India, it is called as IBBI board. That is Insolvency and Bankruptcy Board of India. This was established in the year 2016. So this IBBI, it has the mandate for regulation of insolvency professionals, insolvency professional agencies and information utilities. So beside exercising other powers and functions which is envisaged under IBC code. National Company Law Appellate Tribunal. In short, it is called as NCLT. That means National Company Law Appellate Tribunal. The constitution of National Company Law Tribunal and National Company Law Appellate Tribunal was done in the year 2016. So these bodies, it have been constituted for faster resolution of corporate disputes and reducing the multiplicity of agencies, thereby promoting ease of doing business in our country. So with the constitution of NCLT, National Company Law Tribunal, and CLB, the Company Law Board, it stands dissolved and the case is pending with CLB, that is the Company Law Board. It were transferred to NCLT, that is the National Company Law Tribunal. The cases which were not dissolved by the Company Law Board, it was transferred to National Company Law Tribunal. CSR, it's nothing but corporate social responsibility. In India, corporate social responsibility, CSR for companies, it has been mandated through legislation through section 135. Through the section 135 of the Companies Act 2013. This section 135, schedule 7 of the Companies Act 2013 and the companies, that is the CSR policy or the corporate social responsibility policy rules 2014, it came into force from April 2014. So the corporate social responsibility, it is a self-regulating business model, and this helps a company to be socially accountable to itself, to its stakeholders, and as well as the public. So by practicing corporate social responsibility, which is also called a corporate citizenship, companies, it can be conscious of the kind of impact they are having on all the aspects of society, including economic, social, and environmental. To engage in CSR means, in ordinary course of business, a company which is operating in a ways that enhance the society and the environment instead of contributing negatively to them. It has to contribute in a positive way to the society as well as the environment. This is called corporate social responsibility. Limited liability partnership. So in India, about 95% of industrial units, they are MSMEs, that is micro, small and medium enterprises. As per the survey that is conducted by MSME, over 90% of this, they are registered as proprietorships, and about 2 to 3% as a partnership, and less than 2% they are registered as a companies. So MSME sector, the MSME sector, it is a comparative disadvantage, like the corporate bodies, in accessing loan or credit facilities from a bank and other financial institutions. So there a need was felt for a new corporate firm that would provide an alternative to the traditional partnership with unlimited personal liability on one hand, and the statute-based governance structure of the limited liability company on the other hand. So this limited liability partnership, it is a form of business entity which allows individual partners to be protected from the joint and several liabilities of partners in a partnership firm. The liability of partners incurred in the normal course of business, it does not extend to personal assets of the partner. So it is capable of entering into contracts and holding property in its own name. So an LLP, that is a limited liability partnership, it would be able to fulfill the compliance norms with much greater ease, that is coupled with limitation of liability. The corporate structure of LLP and the statutory disclosure requirements, they are expected to enable higher access to credit in the market. So we are talking about the private company as well as the public company, right? So what is this private company and public company? Let's have a small glance. A private company, it is nothing but it is one which has a minimum paid up share. It has a private companies, it has a minimum paid up share of capital of rupees 1 lakh or more or higher amount or higher capital than that, which is prescribed by the Companies Act. So its article of association, it mentions that the company, it restricts the right to transfer its shares, and the limits of number of its members should be from 2 to 50 members, and it cannot go for invitation from public to subscription to any of its shares, and it cannot accept deposits from persons other than its members, directors and relatives. So talking about the public company, a public company means a company which is not a private company and it has a minimum of 7 shareholders, or we also call them as subscribers. So it has to have a minimum paid up share capital of rupees 5 lakhs. So private company, its members should not exceed 50, that is they should be in between 2 to 50 members, and their paid up capital should be of 1 lakh or more than that. So in the public company, the paid up share capital should be 5 lakhs. MCA 21, e-governance project. So the ministry, it operated an end-to-end e-governance project called MCA 21 for end-to-end service delivery comprising company and limited liability partnership registration, incorporation, registry and other compliance related services. So this project MCA 21, it was started in March 2006. March 2006, on build, own, operate and transfer, which is called as BOOT. That means build, own, operate and transfer model, with the vision was to introduce a service oriented. So this is a service oriented approach in the design and delivery of government services. So with the help of e-services, the MCA 21 system, it provides to the stakeholders a convenient, easy to use and secure access, and delivers all the MCA services with improved speed and certainty. So it has brought about transparency, speed and efficiency in the functioning of the ministry. Investor Education and Protection Fund Authority. So the Companies Act, it provides for establishment of IEPF for promoting investor awareness and protecting their interest. So the amount of dividend or the mature deposits or the mature debentures, application money and so on. So this remained unpaid or unclaimed for a period of 7 years from the date they first become due for payment and they are transferred to IEPF. So Serious Fraud Investigation Office. So next is the Serious Fraud Investigation Office, so which in short is called as SFIO. SFIO, it was set up in the year 2003. The Companies Act 2013, it is an inter alia. It has accorded statutory status to SFIO and its functions and powers have been enhanced substantially with number of enabling provisions in the Act, and it was established under section 211 of the Companies Act 2013. So the main function of SFIO is to investigate corporate frauds, which is of a serious and complex in nature. So it takes up investigation of frauds which is characterized by complexity and which has an interdepartmental and multidisciplinary ramifications. The substantial involvement of public interest, which is to be judged by the size of either monetary appropriation or the number of persons, those who are affected, and the possibility of investigation that leads to or which contributes towards a clear improvement in system, laws or procedures. So this is called SFIO, Serious Fraud Investigation Office. Indian Institute of Corporate Affairs. So the ministry, of Corporate Affairs, it set up the Indian Institute of Corporate Affairs, which is a society registered under Societies Registration Act 1860 to serve a holistic think tank. This is to serve a holistic think tank and a capacity building service delivery institution. So to help corporate growth, reforms through synergized knowledge management, partnership and problem solving in a one-stop shop mode. Competition Commission of India. So the Competition Commission of India, which in short it is called as CCI. This was established in the year 2003 under the Competition Act 2002. So the objective of establishing this commission, that is the Competition Commission of India, was to eliminate practices which has an adverse effect on competition and promoting and sustaining competition, protecting the interest of consumers and to ensure freedom of trade in India. So this Competition Act 2002, it was amended twice. First amendment took place in 2007 and the second amendment was in 2009. So the provision of the Competition Amendment 2002, which relates to the anti-competitive agreements and abuse of dominant position, it were brought into force in 2009 and those relating to the combination from 2011. So this is a brief explanation about corporate affairs. See you all in the next session with some other interesting topic. Thank you.